Hello, everyone. Welcome. Thank you for joining our webinar, Crisis Management in 2022 and the Emergence of the ESG Era, presented in partnership between the Legal 500 and Deep Young. My name is Alan Cohen. I'm a research editor at the Legal 500. And before I hand over the webinar to our impressive panel, I will give a brief introduction of today's topic. Our discussion will be divided into two sessions. In the first one, we will discuss how, since crisis has become an ordinary aspect of business, companies can prevent and minimize risk by creating an efficient crisis management platforms. And then in the second session, we will focus on the importance for companies operating in this context to build a strong ESG index. But first, let me introduce John Rowe, who will lead us through the discussion today. John is a senior foreign attorney at Deep Young. He has extensive experience in advising international clients on the acquisition of various entities and the establishment of joint ventures and subsidiaries in Korea. He also represents Korean clients in cross-border investments projects and M&A deals in various countries, specifically in North America, Southeast Asia, and Europe, including the UK. John is highly regarded for his expertise in international real estate financing, advising Korean and international financial institutions for projects across the globe. And amongst other things, for instance, John was the first foreign attorney to successfully secure an international mortgage over a residential development project with foreign financial institutions as international mortgages in the Philippines. So I'll hand over to you in a moment, John. But before that, I would like to let our audience know that this session is interactive. So if you have any questions at any point during the webinar, please submit them using the Q&A function at the bottom of your screen, and we will put them up to the panel once the presentation is over. John, okay, I'm handing this over to you now. Feel free to introduce the topic further and the panelists who are joining us, and just lead the conversation and get us on the way.
Alan, thank you very much. Thank you very much for the warm introduction. That was a great introduction. Very extensive. I didn't know you were going to go that deep into to my profile. As Alan noted, today we're going to discuss or talk about how crisis management and ESG has most recently evolved in Korea as key areas of management for Korean companies. To give you a more Korean perspective on this, Korea historically in the past has mostly turned a deaf ear towards crisis management when we were in our developmental stage. I think there needed to be a trade-off if we wanted to achieve economic prosperity. In a sense, we needed to sacrifice. We made certain sacrifices with respect to how we dealt with crisis, or how we didn't deal with crisis that occurred in the workplace or in the industry. But now, as Korea has become very economically prosperous and one of the leaders in many of the industries internationally, I think we've geared our attention more towards crisis management. We're putting more efforts into being more socially aware and socially conscious of our decisions. Most recently, Korea enacted the Severe Accident Punishment Act, and that's a significant step towards making companies and industries be more responsible in their decisions and how they approach and address and resolve crises. I don't know if there are many comic book fans in the audience today, but in Spider-Man, Spider-Man's uncle on his deathbed tells Peter Parker, aka Spider-Man, that with great power comes great responsibility. I think that universally applies to Korea right now. With great economic prosperity also comes great responsibility, and I think companies in Korea are taking great measures to become more socially aware, more socially responsible. And today we want to discuss how we can continue on these steps as well. Before going into the discussions, I'd like to introduce the speakers, today's speakers. The first session will be carried out by Sung-Soo Choi and Hoon Lee. Sung-Soo Choi is a partner in our IT technology team. His areas of specialty include public affairs and media risk management, which Mr. Choi has pioneered. He currently serves as legal advisor to the Ministry of Culture, Sports, and Tourism and the National Information Society Agency. He also is the vice president of the Korean Intellectual Property Lawyers Association and is also serving as the president of the Korea Computer Game Law Association. Mr. Choi, please, could you wave hello?
Mr. Choi.
Joining him in the first session is Mr. Hoon Lee, who is a senior foreign attorney in our firm, in our M&A. He's in our M&A group, and he also has extensive experience in cross-border transaction. Mr. Lee also advises domestic and foreign clients on matters relating to new and renewable energy, especially in the areas of wind and solar power generation. Mr. Hoon is an active member of the International Construction and Energy Law Council and is an active member of the Legal Consultation Committee formed by the Ministry of Justice of Korea to assist small to mid-sized companies in cross-border transactions. Now, the second session will be carried out by Chang-Wook Min. Chang-Wook is the head of compliance group at our ESG Center and primarily focuses on various matters related to corporate sustainability, ESG compliance, and human rights management as well. Chang-Wook regularly advises clients on labor, occupational safety, public administration, and other sustainability-related regulations. Mr. Min participated in publishing 13 legislation policy research papers for the government and public institutions. Now, I'd like to render the floor out to Hoon Lee and Sung-Soo Choi to carry out the first session. Gentlemen.
Thank you, John, for the introduction. Okay. Thank you, John. Hello, my name is Hoon Lee. I'm a senior foreign attorney at Japan, as John introduced. For the first session of this webinar today, we'll discuss the crisis management matters. The title, I'm joined by here today, Sung-Soo Choi. So Sung-Soo and I are very happy to discuss crisis management. The title we have today is called Crisis is Everywhere and Every Day. You need a crisis platform. So based on this topic, we'll discuss the types of the crisis that the companies in today's business environment could commonly encounter. And we'll discuss some prominent features of the crisis, and then we'll discuss crisis platform. And by this term, we mean establishing internal crisis management the system together with the support of the external advisors. So let's get right to our presentation. Since we are discussing crisis management, let's discuss briefly on the definition of the crisis. For most of us, we are sure that we have dealt with crisis, at least once or a few times in the course of our lives. We are still suffering from COVID-19 crisis, which has brought many profound changes into our lives in many aspects. So I think that for almost everyone here in this session, I think that the term crisis is a very familiar term. But just formally stating the definition for the purpose of this session, crisis means occurrence of an event that was not expected to occur, which if not properly addressed, may become a material threat that could adversely affect the organization, industry, or related parties. So, in other words, crisis could be a rapidly evolving situation that could pose threat to health or safety of the company's employees, the company's customers, and the public, or the crisis that could put company operation at risk, also creating significant financial and legal and other risks of a company. And also, could adversely affect the company's reputation in a short period of time. So, as you all know, typical crisis would include, emergency crisis like fire and weather-related disasters, and the violent activity, violence and terrorist activities. At more at the company level, crisis could be referred to as like cyber attack, technological failures, personal data security breach, or cancellation of the permit or business license, and also commonly the companies would face the on-site inspection from Korea Fair Trade Commission or Food and Drug Safety Administration. And more recently, the crisis would include, the workplace harassment or the sexual harassment at workplaces, because of the recent changes into Korean law, and also the serious accident, as John referred to in the beginning of this seminar. These, workplace harassment, sexual place harassment, and serious accident. These are a type of the crisis that have recently been occurring in terms of the companies that in today's business environment, been operating in Korea. So we'll discuss these crises more later on in this first session. In order to deal with these crises, the company need to have a crisis management. This crisis management means the act of providing proper guidance on how to respond to various crises to help mitigate or avoid any threats caused by a crisis. So crisis management simply means handling the crisis in appropriate manners, so as to minimize the legal, financial, other risks of the company, and at the same time maximizing protection of the company and its employees. So today's crisis management has become more important and critical to a company because of the some prominent features of the modern crisis situations. For instance, one maybe crisis becoming more common and prevalent. Companies face various crisis situations that they never experienced before. Such as workplace harassment, sexual harassment at workplaces. These types of crises were existed in the past, but have become more commonplace because of the recent changes made into the law that include amendment to the Labor Standards Act, and also the recent enactment of the Serious Accident Punishment Act. And also the second one being crisis becoming more multi-layered and complex. Say like personal data security breach. If the breach occurs outside of Korea, it is difficult to identify a cause of the crisis. Also, because of the breach taking place, not in Korea, outside of Korea, there may be complexity as to which laws should apply, Korean laws or foreign laws. So there may be some sort of complex jurisdictional issue for such a crisis. Also, serious accident. In the past, when a crisis of a worker getting injured at a site of construction, then the related parties will be confined to the worker himself or herself, and also some low-ranking officers relevant to the site. But now that because of the recent law enactment, now the related parties would reach far beyond the parties, reaching the company's management and even the company the president. Also, the last being crisis being amplified and becoming widespread through expanded reproduction. This is very because of the change in the media environment and also the rise of social media. A crisis that was not there would be small scale in the beginning, would be widespread in a short span of time if not properly taken care of at the beginning of a crisis. So this slide shows a famous formula that you could easily recognize, and this formula could be also represent cost of crisis management. So cost of crisis management would equal conflict factors that consist of social outrage, disrespect, resentment, and disappointment, multiplied by lapse of time, and then squared by the civic groups, social activists, and press and media. It's just this formula shows that if these conflict factors of the relevant to a crisis are not properly taken care of or minimized in the beginning of the crisis, then things would escalate. Crisis would become really large scale level to a level that the company no longer be managing effectively. So compared to the past, crisis management is needed because today's crises are different from the past crisis that they would impose legal and social damages to the affected companies. And in the past, company would just act based on their good intentions. They'll just examine a crisis, not closely, just based on cursory examination of the crisis. They would act, but they would not be sufficient in this today's business environment. If the company acted only based on their good intentions, based on their cursory examination of the crisis, they would bring unfair consequences accompanied by the huge amount of the cost caused by legal claims for damages. So we would strongly advise that the company with large operations, medium-sized operations at least or above, to establish crisis response plan, by which the company would self-evaluate the various risks a company could encounter in today's business environment. And so under that, it would be critical to have a crisis response plan to have the capacity of the responding to various demands of the governmental agencies and to the public and to other related parties. And also in addition, you also necessary to establish internal system to control crisis comprehensively, and together with the support of the external advisors in order to deal with the legal liabilities, because damage amount would be could be huge under the the current criminal laws. So we have talked the types of crisis the current the companies could encounter more and more in today's business environment. We have discussed the gist of the crisis management. Now, as I said at the beginning, I think it's worth to discuss a little more in detail the work harassment crisis, and also the sexual harassment, the crisis and serious accident, the issue, because these are more given more attention by the companies operating in Korea because of the the recent law changes that has strengthened the protection of the employees at workplaces. So my colleague Sung Soo will take over and then discuss these issues.
Okay, thank you. Regarding the crisis management Korean companies, it can be said that workplace harassment and sexual harassment in workplace and the serious accident punishment law are two main issues recently attracted most attention. Firstly, the gist of the workplace harassment is as follows. The Labor Standard Act stipulates the obligations of the employer in relation to the workplace harassment. The employer must take appropriate measures in the event of workplace harassment. As we may see in this table, the most violation of the obligations are subject to administrative punishment, but the third type is sentenced to even to imprisonment. The second type, right, no player should treat the employees who report the occurrence of workplace harassment or employees who suffer or claim to suffer workplace harassment unfavorably. And next, sexual harassment in workplace. The obligation of business owners are stipulated in the Gender Equality Act. Most of them are also subject to the administrative punishment, but imprisonment is also possible to violation of prohibition, disadvantageous treatment. Since the above legal obligations and punishment are stipulated, an appropriate preventive response system should be prepared, and an immediate response is required in the event of incident. That's right. So in conclusion, workplace harassment and or sexual harassment in workplace, any employers who fail to take appropriate measures under applicable laws shall be subject to more as a correctional order or criminal punishment. And secondly, it is necessary to establish an appropriate preventive response system and immediately respond to any case of sexual workplace harassment upon occurrence thereof. And second hot area is area of Serious Accident Punishment Act, in short, SAPA. The SAPA became effective as of January 27th, 2022. If a serious industrial accident or a serious civil accident occurs in a business with 50 or more full-time employees, in case of a construction project, if the construction price is 5 billion or more Korean won, the business owner or CEO of such business shall be subject to criminal punishment. And if the joint penalty provisions apply, even a corporation may be punished by administrative fine equal to billions Korean won. Among other things, it should be noted if violation of SAPA occurs, business owner, the CEO is subject to criminal punishment. Since manufacturing and construction are the backbone of South Korea's industry, the risk of serious accident is everywhere. If an accident arises in the workplace, it is important to minimize the damage in the first place to prevent the application of SAPA to such an accident. And any companies subject to the SAPA should take the following actions. Many actions: responding administrative proceeding, as well as criminal proceeding, responding civil proceeding, and dealing with press and media attention, dealing with bereaved families, dealing with civic groups, and managing a company's reputation, and managing government and parliamentary relations.
Okay. Thank you. So just, these recent amendment to the Labor Standards Act and the enactment of the Serious Accident Punishment Act creates, the level of attention that the companies in Korea need to give in terms of preventing, also dealing with the crisis, especially the SAPA is very the early in the stages of enforcement. So the company should take appropriate measures in order to prevent the application of SAPA. So let's move on to next slides. We'll talk briefly of some examples of companies for responding to a crisis. Because of the time limitation, Sung-soo will introduce just one example of a case where the company has badly mishandled a case, and I will follow up with with a good example of handling a crisis.
Okay, let me introduce a sample case, a recent case in which a Korean company responded very incorrectly to a crisis response and greatly damaged the company's reputation. It's a company G case. The details of the fact the following. Customer A bought brand F, they mistypo E, brand F t-shirts from company G, a fashion platform. Customer A resold the t-shirt on platform D, one of the reselling venue of Naver. As a result of platform D's inspection, it turned out that the product was counterfeit. When platform D issued a notice warning of counterfeit product, it exposed the brand name of company G. The company G's response is the following. It denied the allegation of the counterfeit sales with a statement, the product authenticity has been reaffirmed by the official distributor, expressing its disappointment toward platform D and requesting D to remove the notice. Mic problem? Okay. Skip 21 slide. Okay, so in this case, we are analyzing the company G has mismanaged crisis management in the following aspect. Firstly, inconsistency in the messages, especially evasive response from marketing and purchasing department of the company. It requested an appraisal of not the item in question, but a product from the same distributor, a different item. It took passive action in disclosing the information, including the purchase information and number of items sold. And taking a hardline stance from the legal affairs part of that company, it worsened the conflict by belittling by rival companies Platform D's competence in customer persuasion by saying that the brand maker has sole authority to verify the authenticity of the product and pressing the dispute raised with its legal authorities. And it announced its plan to file a criminal complaint to the court and a petition to FTC against the Platform D. Second, fourth, the failure in crisis management due to the absence of command center. During the initial phase of the crisis, the company G failed to identify the characteristic of the crisis, sporadically respond to the issues. As a result, this led the company G to fall under the influence of uncontrollable factor, that is a decision made by product manufacturer. Company G had confidence in the authenticity of the product in question without retrieving the product customer A sought to resell. It requested an appraisal of different item from the same seller. It maintained hardline stance despite its receipt of appraisal result of unable to verify its authenticity. So it triggered a bigger confrontation by unnecessarily attacking Platform D. It sent excessive message dragging Platform D into uncompromising battle if seen from the D's perspective, such as Platform D's inspection result is based upon appraisal agency's arbitrary standard and it lacks credibility. An uncontrollable exit plan. Company G received a fatal blow after receiving appraisal result from the product manufacturer, which found the product in question as a fake. Lastly, the lack of responsibility due to the absence of the command center. Absence of apology from a company's CEO level after brand F issued appraisal result, finding the product in question as a counterfeit. 4 days after brand F found the product in question to be counterfeited, Company G only issued a press release. It would enhance inspection process for luxury goods. It maintains its push strategy by bombarding the public by press release, emphasizing we are still maintaining our upward tendency in growth. This is the bad example of the crisis management. Okay.
Thank you so much. Just to sum up this case, this bad case of handling a crisis, I mean, it's a lack of a control tower in responding to a crisis. And also the inconsistent messages coming out of the company. It emphasizes the need to have the internal system or control tower to respond to a crisis. And my example is the contrary to the case just mentioned. this company A is a Korean subsidiary of a global company in Korea, and the company A has established and operating the integrated crisis management system at the company level. And under this system, it regularly monitors the various risks this company faces, and it also has the in-house experts to examine various risks, reinforcing its risk management system. So also has compliance council. This company has this compliance council. The members are the heads of the various business divisions of this company, and they meet on a regular basis to discuss important matters and current issues related to examination of the compliance risk, focusing on the direction of improvement activities, and also while sharing the trends in legal and social regulations that have drawn public attention. So, this kind of internal, having this internal system to manage crisis, to manage the risks this company faces in connection with its business, and also having a compliance council. This would effectively, raises the company's alertness in terms of dealing with the crisis. And I think that we see that more and more companies are, establishing their own, the compliance council functions in order to track down the trends in legal and social regulations, in part because of the evolving changes in Korean laws, especially the court, Korean courts and the position on these matters of law. Korean courts have been recognizing the liability of the companies for damages caused by a tort, and also the employer's liability for compensation under the Civil Act. So I think that for companies operating in Korea, they need to have their own, council. If not, if not compliance council, they need to have some sort of mechanism or system by which they need to monitor, what's going on in the legal trends of Korean laws, including the positions of Korean court cases. So we are coming down to the last slides. We have, I think we are stating, we may be stating the obvious. I mean, I think that in order to deal with the crisis that the companies would encounter, more often, as compared to the past, the workplace harassment, sexual harassment, and the serious accident issues, in addition to typical the cases of crisis, including the site inspection from the governmental agencies. I think that it has become more necessary. It has become more, I think it has become sort of an absolute necessity to have to install and establish internal crisis management system, and under which I think there should be three critical functions. One is crisis prevention phase. The second phase being crisis response phase, and the last one being recovery phase. Under the crisis prevention phase, the company would regularly conduct examinations on the crisis that may pose a threat to companies the business activities, and for each type of the crisis they may they have evaluated. I think that it would be good to prepare scenarios by which they will respond to a crisis. And as for the unpredictable crisis, it is necessary to establish strategies to minimize the possibility of the business suspension. And moving on to crisis response phase. If and when a crisis occurs, I think that the company should have internal communication system by which the company would respond to manage the company's reputation, and the coordination of the current and future response to victims, and also the managing the company's civil and criminal liabilities that may arise from the crisis. And also it is also important, it's very important to analyze press releases, what goes out before it goes out to the outside, they have internal consensus on what to put into press releases, and also the monitor social media posts and comprehensively control outgoing messages. Also the support of the external advisors, utilize internal and external experts to support the process within to deal with the crisis by the company's management. In the recovery phase, I think that even if the crisis has been settled down, it's not over. It's not over yet. There may be ensuing court proceedings to deal with the company's the civil and criminal liabilities. So during the recovery phase, it would be necessary for the company to work with the outside legal counsels in order to minimize the exposure to damage claims, and also minimize the ultimate the amount of the damages that may occur. So just to conclude, to manage crisis more comprehensively and systematically, a system dedicated to crisis management must be operated. And in particular, the crisis management system should gather crisis management capabilities of a company to support the executives and the board of directors to make effective decisions to handle various crises. So thank you for listening to us. Now we will have Q&A sessions towards the end. We will move on to the next session. John.
Yes, gentlemen, thank you very much. That concludes the first session. The second session will be carried out by Chang Min. He will discuss why legal compliance is not enough and why you need to have an ESG approach to risk management. I'll concede the floor to Chang-wook.
Just a moment, I think she's still finalizing the camera. Oh, and the slides. Okay.
Oh, hello, this is Chang-wook Min, and I'm very glad to speak in this webinar. And my topic is compliance and ESG risk management. So I'm going to talk about the three topics: introduction and ESG risks and stakeholders, especially in South Korean context, and compliance program in the ESG era. First of all, what is compliance? The traditional meaning of compliance was ensuring the firms and its individuals are complying with all the relevant laws and regulations. And all the laws and regulations were enacted by the government. So the role of the traditional compliance manager was to screen all the relative laws and regulations applied to the company, which was enacted by the government. But the meaning of the compliance has broadened. For example, last year, the ISO 37301, which is an international standard of compliance management system, was published, and it says the definition of compliance is not only the laws and regulations, but it expands to the organization standards, best practices, and even the community expectations. Those organization standards are not enacted by the government. And these days, the companies are required to follow those kind of, even the best practices like that. So why does that happen? I think this is closely related to the change of regulatory environment in the ESG era. To be specific, in the past, the domestic government enacted hard laws and firms complied with them. And other than that, NGOs and local communities, they raised some kind of civil movements, and the firms responded to the CSR activities. That was the past. But in the present, not only the domestic government and the foreign government, which enacts the hard law, but also the many private institutions, they make soft laws to regulate the firms. Some scholars call this phenomenon as a regulatory pluralism, which means that the private institutions such as standards and framework setters or raters and rankers and ESG data providers, they are private institutions, but they play the role of the government to regulate the market. And also in this ESG era, investors, especially the institutional investors, they're they're aligned with the private institutions such as standard setters, and they engage with the target firms about how they manage the ESG risks and like that. And due to the technological developments, all the consumers, they raise their voices more often. So I think this is the phenomenon of the ESG era, and the companies are required to comply with the other private institutions and stakeholders. So let's talk about the ESG risks and the stakeholders, especially in South Korea. First of all, as you can see in this ECI recent report, there are a broad array of non-financial topics covered by ESG rating agencies. Like in the environmental section, there are clean air, water use, green building. And in social section, there are human rights, workplace violence, privacy. And in government section, there are anti-bribery and fraud and business ethics like that. But my point is, who's raising these kind of various ESG topics? Who's claiming that? Let's see, in this ESG era, there are stakeholders. For example, Korea National Pension Service, NPS, which is one of three of the top national pension funds in the world. They introduced stewardship toward, and according to their website, they say MPA conducts shareholder engagement on 5 focus areas, and one of the 5 focus areas is ESG rating downgrade. And also they conduct shareholder activities over ESG related unexpected concerns. So as you can see in this chart, whenever they find the target company's ESG rating downgrade, the MPS sends a letter and start engaging in the private dialogue. And then they put them on the non-public focus list, and then to the public focus list. And then when there is annual general meeting, they file shareholder proposal and engage in the active ownership activities. And not only the NPS, but also the Dutch pension fund, APG. Early this year, APG sent letters to 10 CEOs of the Korean global companies, and to urge them to transform to the low carbon businesses. And also the interesting event was in this annual general meeting season, APG aligned with one of the Korean NGOs, and they filed a resolution on the ESG issues. To be specific, they required HDC Hyunsan, it's one of the largest construction company in Korea, and they had a safety accident early this year. So they required HDC to amend their articles of incorporation and to establish a safety committee under the board and nominate at least one director with who has a expertise on safety issues. So those kind of institutional investors are raising their voices on ESG issues. And also there are like standard setters, mostly the SASB. They made a corporate sustainability disclosure standard, and most institutional investors, including the BlackRock, they engage with their target companies to follow those SASB standards and disclose their sustainability related business topics. And also there are raters and rankers. In Korea, Korean government, corporate government service, KCGS, is the largest ESG rating agency in Korea. And what they're saying is they have like 265 plus 58 core evaluation criteria on ESG topics. And they yearly awards like best ESG companies. And many companies are trying to focus on managing their ESG issues and to get the good ESG scores from the KCGS. And also business partners are pressuring their contractors and their suppliers to manage the ESG risks. For example, many global companies now have like supplier code of conduct, and they have supply chain evaluation system. Like as you can see, the Hyundai, the motors, they created evaluation indicators that consist of like 155 questions, and they evaluate their suppliers, and the suppliers are like pushed from the like Hyundai Motors and other big companies to manage their own supply ESG risks. And also the consumers, they're raising voices, and companies are facing boycotts and claims when they are not able to manage their ESG risks as well. Yeah. And lastly, compliance program in the ESG era. Let's see, the traditional compliance program meant that prevent, detect, and respond, mainly the criminal conduct. For example, the bribery or the corruption. Those were mainly the legal risks. But in this ESG era, I think there are so many soft laws, like many initiatives or many guidelines. These are turning into hard laws, and they become the regulatory risks in the mid to long term. For example, in 2011, the UN guiding principles on business and human rights were like endorsed, and it used to be the soft law. But 10 years later, many countries in the EU, they enacted human rights due diligence law, and it has become a hard law. So I think many compliance managers or compliance officers have their risk profile or risk pool in their company, which they list certain legal risks and they define the risks. But I think the compliance officer should add some important soft laws on in their business or in their industry, so that they need to estimate what other like soft law risks here in this ESG era. And secondly, there are greenwashing regulations in products and services. In Korea, there's an Act on Fair Labeling and Advertising, and it says some labeling and advertising that is likely to undermine fair trade order by deceiving or misleading consumers are banned. Last year, the end of the last year, there was there was a claim that a South Korean company, SKENS, they said that they have a natural gas project, which is like CO2 free. But one of the NGOs in Korea, they claimed against SK for this labeling is false and is deceiving and misleading consumers because they think that it's not a CO2 free. So I think in many companies, there are like IR teams or consumer teams or product teams. They make their own advertisements But in this ESG era, I think compliance officers or legal experts should have to cooperate with those higher team members, and they need to check whether in their advertisements, whether there are like greenwashing regulation risks or not. And also in this ESG era, many companies conduct ESG due diligence in their supply chains. In my experience, many CSR departments, they conduct those kind of ESG due diligence. But in my opinion, when you look closely on their checklist specific items, those items are very closely related to like legal interpretations. For example, in S part, the checklists they have like certain labor rights or international labor organizations, the conventions like that. These kind of items need a legal interpretation. So I think CSR experts and the compliance managers in a company should get together to make and define and revise those kind of ESG due diligence checklists as well. And also in supply chain management, there are potential legal risks in Korea. For example, if a company provides a educational training to the workers in their supply chain, this action could be considered one of the factors of illegal dispatch, which is banned in Act on the Protection of the Temporary Agency Workers in Korea. And also, if a company terminates contracts due to some kind of ESG issues, this could possibly constitute an unfairly refusing transaction according to the Fair Trade Act. So whenever like procurement department or like other colleagues, they take some kind of action to manage their supply chain, I think there are always like potential ESG like legal risks out there. So I think the experts or the compliance managers should cooperate with other departments, especially the procurement department as well. And lastly, I think there's the Allianz, the insurance company. They have a very good, ESG risk management processes. According to their ESG integration framework, they have ESG referral process and the sensitive business guidelines. For example, whenever they plan a insurance or investment transaction, they screen at entity level using the sensitive business guideline. They set up some I think 16 the sensitive business areas, like including in defense or mining or nuclear energy like that. Whenever there's a transaction in those areas, they try to identify potential ESG risks based on their own guidelines. And whenever they found some kind of certain ESG risks, they analyze and assess those kind of risks and take different kind of actions. For example, whether they could proceed a transaction or they could proceed with the mitigation measures, or they just decline the transaction on ESG grounds. So when you look closer to the sensitive business guidelines, for example, if there's like mining sector, there are like all the standards and sources like IFC, GRI guidelines, and initiatives. These are all soft laws, I think. So they listed up all the applicable, soft laws, and then they try to figure out the specific risks in this mining sector. So I think it is very important for compliance managers or officers to set up those kind of the risk profiles or the guidelines, and then check all the ESG risks in their business operations. Thank you, and thank you for listening.
Thank you very much. That concludes the second session. I think the next session is the discussion portion of this webinar. I think these sessions went a little longer than expected. We apologize for that, but maybe perhaps we could speed up the questions. And Alan, I'll give you the reins to kind of source through the discussion portion.
Yeah, no, not a problem at all, Jonah. Yeah, it went a bit longer, but that's perfectly fine. You know, I'm sure my production team won't bother me about that. So there were a few questions. Some of them were answered as you were speaking. But I think one has in this first one, a question to Mr. Min. Can new technology help in-house legal teams to improve their ESG index? Thank you.
Can you say that again?
Absolutely. Can new technology nowadays help in-house legal teams improve their ESG index?
You mean is there any ways to improve their ESG index to the compliance managers in the company? Yeah.
I suppose so, yes.
Oh, yeah. The first thing they have to do is they have to figure out what applicable, I think, soft laws or other soft regulations on their own business areas. There are some, for example, there should be some guidelines or there are some alliances or like that. And they need to figure out which stakeholders or which or NGOs or which business standards they encounter, and they need to check those kind of items. And there are specific ESG items they pause or they require to the company. So they need to the managers should figure out what specific things they require, and then after that they need to cooperate with all the other colleagues in the department to respond to their stakeholders' voices. Yeah.
Thank you very much, Mr. Min. Another question, I think that will be for Mr. Lee and Mr. Choi. Has there been any cases where the SAPA has been applied, and when would the SAPA apply to businesses of less than 50 employees? And you on mute, gentlemen.
I can tell you the second question. This SAPA shall apply to sole proprietors and business with less than 50 full-time employees and construction project less than 5 billion Korean won from the January 27th, 2024, 2 years later.
Yeah, I mean, the first question, I mean, it's the law SAPA has just come into effect, into force just only this year. So there have not been any formal prosecution of the cases, but we understand that there are cases where the government is investigating the current violations, but not actually indicting anyone up into the state. But but I think that in over time there will be actual cases of the government enforcing the SAPA.
Most cases related to SAPA are currently in the investigation phase, and it's necessary to monitor further development.
So,
Thank you very much, gentlemen. No other question. There were a couple of remarks. Some people in the audience were interested in having your PowerPoints after the webinar. So I think this can be arranged. Just reach out to John, or just express the request now, and we'll share it. Not a problem at all.
Alan, I do have one question.
Yes.
To Changwook. With respect to the compliance officer, is there any set statutory criteria that they have to satisfy? And normally, who do companies designate as compliance officers? Does it have to be a neutral third party? Could it be somebody within the company? Just to give some basic instructions on who you can nominate as a compliance officer.
John, that's a good question. In commercial act in Korea, certain companies will have have lots of how to say the profits. They have to nominate at least one compliance officers based on the commercial act, and this commercial act has specific requirements, and for example, they used to be like lawyers and have the profession in law or something like that. But other than that, many companies there are no like regulations on nominating a chief compliance officer. Yeah, so maybe they can figure out the right person in this company. And,
okay, so it doesn't have to be outer extra company person. It can be somebody within the company.
Yeah. And also for the first question, I'm very sorry that I just read the question right now. The technology, there are many ESG solutions, yeah, because that helps the company to manage all the data, ESG data, right, like that. So maybe if the legal teams, they use those kind of ESG solutions, the technologies, maybe they can put all the like soft laws or all the soft regulations or the hard regulations in the technology, and then they can sort it out, and they can update so that maybe it is easier to figure out the hard load risks and the soft load risk, let's say, like that. Yeah.
That makes perfect sense. Thank you. Gentlemen, I don't see any other questions. John, I don't know if you want to say a closing word.
Oh, no. Well, not a closing word, but I just want to thank Hoon Lee, Sung Soo Choi, Chen Min in preparing the seminar material, preparing the speaking sessions.
Okay, wonderful. Well, again, and I'd like to, thank GPM again for collaborating with us on this. Thanks to the panelists and to the audience, and we hope to see you at another webinar shortly. Then, goodbye, everyone.
Thank you.
Bye.